You want the good news first or the bad? Good news? Bad muna, yeah? The bad news is the bar exams will proceed as scheduled. So that will be next week. Next month. Good news is, I already know your examiner. He is a lawyer. Do not expect justice in the bar. There is no justice in the bar. Some fail not knowing why, others pass not knowing how. Accidental lawyers. No? There is no due process in the bar. Tax is your strongest subject. You get 49. That is under due process. Worst subject is labor law. You don't even want to take the exam in labor law. But you get a 99. That is over due process. So don't expect justice in the bar. That was supposed to scare you. Why are you smiling? I intended to scare you. Why are you smiling? Let me try once again. There are 8,700 of you taking the bar exams this year. 8,700 maximum. If your examiners are given 4 months to correct your notebooks, let us give them 4 days of rest a month. So in 1 month, they should be checking your notebooks in 26 days. So 26 times 4 months equals 104. You divide 8,700 notebooks by 104. They should be checking 84 notebooks a day. And usually, the number of pages written on is 30. So 30 times 84 notebooks will be 2,500 pages per day. Each examiner should be able to read 2,500 pages per day. You think he will be able to do that? Impossible. No? So you keep your answers very, very short. As short as possible to ensure that they will at least be read. And how do you keep your answers brief without sacrificing substance or content? The 3 elements you should put into your answers are brevity, clarity, and coherence. Brevity, clarity, and coherence. Do you know of the Alcantara method or approach? Okay, so brief but complete. Was A validly dismissed? Answer is yes or no, diba? If you know the answer, you are sure of the answer, yes, period, and that is a statement. No need to write yes, comma, A was validly dismissed. You reserve the additional words, A was validly dismissed, for your conclusion. Kasi the 3 paragraphs ka to give physical balance to your answer so that visually it will be powerful, impressive. Okay? So, yes is a statement. Each time you make a statement, you ask the relevant why. Yes, why? And that will be your next sentence, which will be the first part of your second paragraph. Leave a space, indent, answer the question why. Okay? Why? Yes. Okay? A dismissal to be valid must be for a just cause, diba? That is your theory, that is doctrine, that is principle. Okay? A was dismissed for a just cause, comma, okay, namely, abandonment of work, period. Is that a just cause? Is the next question to ask. And you know that it is not, because it is not a listed cause. So you have to tell the examiner why the dismissal grounded on that unlisted cause is valid. Okay. Although abandonment is not a listed just cause, it justifies a dismissal because it is an analogous cause, period. Okay. Why or how is it an analogous cause? Okay. Perhaps the question to us is why. You answer that, and that is your next sentence, which must be short also. Okay. It is an analogous cause because it approximates or it is similar to, okay, which of the listed causes? Gross and habitual neglect of duty. Period. Next question to us perhaps is how you answer that. Then if you cannot ask any questions anymore, then you are certain that your answer is complete. So go to your reconclusion. What is a reconclusion? A repetition of your conclusion, of your yes, no. But this time, therefore, comma, A was validly dismissed. So very short, very clear, very coherent. Okay, ganun kayo, okay? Now, you are expecting 20 essay-type questions. And you have been told that each main problem will come with sub-questions. Usually, the sub-questions are interrelated. In labor law, SSS, ganito yung lagi nilang tinatanong, or this is how they frame questions. Letter A, facts. Letter A will be employer-employee relationship. Is there employer-employee relationship? Letter B, does A have the duty to report B for SSS coverage? That was done twice already. So you will take note that in Bar 2014, involving Don Luis and Lando, ganito yung tanong. Don Luis went to church. He was approached by Lando. Lando wanted work from him, but Don Luis dismissed him. He did not need Lando. He went home, looked at his plants, realized that there was a need to trim his plants. He remembered Lando. So he went to look for him, brought him home to trim his plants. Questions. Letter A. Was there employer-employee relationship between Don Luis and Lando? Okay, yes or no? Huh? Letter B. Did Don Luis have the duty to report Lando for SSS coverage? Ang tinatarget ni examiner yung exclusions. Yung mga tao na walang SSS coverage like purely casual employees. Okay. So yun ang tinatarget niya. So you have to surface the key term, purely casual employee. Yun yung sagot sa letter B. But you cannot have a purely casual employee in letter B unless you affirm employer-employee relationship in letter A. Di ba? So kailangan may employer-employee relationship between Don Luis and Lando in order to have a casual employee in the person of Lando in letter B. So what do you notice? That sub-questions are interrelated. Look for the connection. Okay? Do not answer the sub-questions in isolation of each other. May connection yan. But there are instances also that there is no connection. Like in one barrier, ito yung sub-questions, A, B, C. When is there a wage distortion? Letter B, how is a wage distortion resolved? May connection ba? Wala, di ba? Wala. Letter C, is a wage distortion a proper subject of a notice of strike? Walang connection. So pagka ganun, walang connection, go ahead. Answer those sub-questions independently of each other or one another. So, I just wonder if the time given you, 4 hours, will allow you to do that kind of work, mental work or analysis, no? Mukhang all you have to do is scan the questions and write. Okay, so practice your handwriting. You practice how to write fast. Okay. Avoid erasing because your erasures will only invite the attention of the examiner to your wrong, defective, incomplete answers. Kung minor lang, huwag mo nang i-erase, ha? Huwag na. Remember that somebody became top 10, okay, with several blanks. How did that happen? It's an overdue process. So just keep your notebooks clean and impressive. So which one should we tackle first? There are three types of labor law. Actually, there are four types now. The fourth type is environmental labor law, which is the subject of Dean Pokis because is the green type of labor law. Three, if you are asked to give four, but you will not be asked objective type questions now, essay lahat, okay? Just in case, the fourth would have to be labor principles. Labor principles. Otherwise, there are three. And there are walls separating these types of labor law. Walls tall enough for you to be able to recognize each type of labor law from the rest. So you know that labor standards law guarantees minimum terms and conditions of employment, like conditions having to do with wages, hours of work, okay, and extra wage benefits. So it is an employment law, meaning it operates within employer-employee relationship. In contrast, social legislation operates within and outside. Okay? And it is to guarantee social security, okay, both to employees in the private and public sectors. Ganun yan. Si labor standards, private yan. Private. Now, here is a 2018 decision penned by Justice Yunen. Napabasa nyo, nasa headline ngayon. Involving a DO issued by the Department of Labor and Employment. I am referring to DO 118-12. Now take note that this decision is 2018 and therefore it is outside the cut-off date. Okay, outside. But this decision involves issuances of the department and the LTFRB, which are 2012. And in the decision, there is mentioned, Justice Yunen applied a provision of the new civil code, which is very much a part of your power coverage. I am referring to Article 1700 of the new civil code. So the chances na magbigay ng tanong dito, based on this, using this new decision as anchor, is there, or are there, okay? Chances are there. So, ano itong kasong to? 2012, the Department of Labor and Employment issued DO 118-12. Okay? Take note of two salient provisions of this DO. Number one, maximum hours of work for bus drivers and conductors. 8. If required to do overtime, it cannot exceed 12 hours. Okay. Number 2, they should be paid mixed compensation consisting of basic salary plus performance-based commissions. Now, sumabay si LTFRB. Naglabas ng Memo Circular 2012-001, requiring bus operators to first secure labor standards compliance certificates from the Department of Labor and Employment as a condition for the issuance of their franchises. These issuances were challenged by the Provincial Bus Operators Association of the Philippines and similar groups. Case went up to the Supreme Court, where the issue resolved was the validity of these issuances. Allegedly, they violated the Due Process Clause, the Equal Protection Clause, and the Non-Impairment Clause. Ito na ngayon si Justice Yunen. Sabi niya, no violation. Okay? Because DO 118-12 is social legislation. But take note that DO 118-12 provides for hours of work, provides for compensation salary. So it must be labor standards law, di ba? But in this case, Justice Yunen treated it as social legislation. So pakitignan lang ito, okay? I don't know how the examiner would craft a question based on the erasure of the wall separating labor standards law from social legislation. Just take note of this case, okay? In a 218 case, just tell the examiner, okay? No need to cite the exact title of the case because, in fact, we are still looking for the title of that case. Okay. how important are types of labor law? Very important because of 95, 97, 2003, 2006 bars. In 95, the question was 3 types of labor law, and then distinguish labor legislation from social legislation. In 97, okay, distinguish labor standards law from labor relations law. Are they mutually exclusive? 2003, okay, what is the interrelationship between labor standards law and labor relations law? 2006, what is the purpose of labor legislation? So if this area was inquired into as many times as 4 times, then it must be a bar area. It must be a bar area. Now, if those were the questions asked in that or in this area, what are the possible questions that may be asked in the same area? Number 1, not yet asked, is the double indemnity law. Republic Act 8188. What is the nature of this law? Under this law, an employer who does not comply with a wage order, in effect does not pay prescribed salary increase or increases, can be ordered to pay double the amount of the wage that he has unlawfully withheld. So it's times 2, right? Double indemnity. And on top of that, he can be criminally prosecuted. And in the case of Sapio versus Untalo Construction, the Supreme Court told us that payment of the unpaid wage does not bar criminal prosecution. Now, this law applies only if what is withheld is wage, okay? So that you do not double applying this law, back wages, and separation pay in lieu of reinstatement. So it is back to distinction between labor standards law, labor relations law, if not labor dispute, labor standards dispute, labor relations dispute. So you only apply the double indemnity law to labor standards cases, specifically cases involving non-payment of wages. Number 2 possible question. Judicial characterization of labor standards law as extraterritorial. Which makes, or what makes Philippine labor relations law extraterritorial so that it can be applied even outside Philippine territory? It used to be Section 10, 8042, the Migrants Act, which is now Section 7, RA 10022. So what happened in SIM versus NLRC? The employment contract sued upon was executed in Italy. When the banker was dismissed, she came home to file a complaint against her bank. The bank moved to dismiss the case on what ground? Lack of jurisdiction. Why? Because the contract sued upon was executed on Italian soil and therefore, according to the bank, was governed by Italian law. And invoking lex ex contractum, lex loci celebrationis, the bank argued that the labor arbiter had no jurisdiction. Supreme Court said he had jurisdiction because Corazon Sim was permitted by Section 10, 8042 to litigate before the labor arbiter, to bring her money complaint to the office of the labor arbiter. So, because of Section 10, RA 10022, Philippine labor relations law has become extraterritorial. Since Section 10, 8042 is now Section 7, 10022, tell the examiner that Section 7, 10022 has made Philippine labor relations law extraterritorial. Third possible question. State your agreement or disagreement to the following propositions. Noong araw, ginamit yan na bar form, okay? Pero isa yung binigay na proposition. If I were the examiner, because I want to challenge your intelligence, I will give at least 5, and one of the 5 propositions might be this, okay? Labor standards law is a substantive law, whereas labor relations law is a remedial law. The answer to that is I agree. Okay. From your civil procedure, when is a law substantive in character? When it creates rights and when it imposes correlative obligations. Okay? And exactly that is the function of Book 3 of PD 442. It creates rights for employees, at the same time imposes on their employers the correlative obligation to respect those rights. So, to that extent, labor standards law is a substantive law. Now, in what sense is labor relations law a remedial law? Understand remedial law in its simple concept of a law that provides remedies. Ganun lang, hindi yung procedural adjective law ninyo sa civil procedure. Book 5.6 give you procedures. Okay. Remedies for the improvement of terms, minimum terms and conditions of employment. So for that reason, you can characterize labor relations law as remedial law. So this one we got, of course, from Professor Chan. Next, solidary liability of principal. Solidary liability of principal. What is the extent of the solidary liability of a principal? Answer, it depends on the status of his contractor. If his contractor is a legitimate job contractor, that solidary liability is limited. Limited to what? To wages, benefits not paid by the legitimate job contractor. Which means that you cannot stretch that solidary liability as to make the principal liable for the consequences of an illegal dismissal committed by his legitimate job contractor. So, back wages, separation pay, due of restatement are outside that solidary liability. But if the contractor is a labor-only contractor, in which case the principal is the real employer, the actual employer, with this contractor being his agent only, a recruiter of manpower, then the extent of the principal's liability is comprehensive. It is a top-to-bottom kind of solidary liability. So again, it is labor standards law versus labor relations law, if not labor standards dispute versus labor relations dispute. And finally, okay, 10% docket fees. When can you dismiss an appeal on the ground of non-payment of docket fee or appeal fee? The case is a labor standards case. Why labor standards case? Because it was initiated by a verified complaint seeking payment of unlawfully withheld wages. So labor standards case yan. Natalo si employee, mag-a-appeal siya, di ba? In order to perfect his appeal, he has 10 days within which to perform two things: file his appeal memo and pay the required docket fee. If he does not pay that fee, would you dismiss his appeal on the ground of non-perfection? Answer is, it depends. Okay? It depends on what? Labor standards dispute versus labor relations dispute. Since the case involves money, then it must be a labor standards dispute or case. So you will apply the portion of Article 292, which says, in labor standards disputes, workers shall not be assessed docket or appeal fees. Okay? In other disputes, they may be assessed. So since, as I said, the case is labor standards, you do not assess the worker appeal fee. So that has not been given yet. I hope that will be given as number 1. Tapos 90 points. Nako, 10 points na lang hahabulin nyo. Okay. So those are the probable questions in the area of types of labor law. Okay. So let us now focus on the most neglected type of labor law, which is social legislation. How much of social legislation do you need to top the bar to get 100 in labor law? Remember that somebody got 0 in labor law last year, di ba? Siguro may markings yun. Hindi naman sila 0 sa substance. Marking siguro. Na 0 siya. Except in 1987, when there were several questions, all on SSS, I believe about 6 of them, it is maximum of 2 questions on SOCLEG in the bar. And usually, it is from SSS. Usually, it is from SSS. Why SSS? Kasi that's the law that applies to the private sector. Labor law, private tayo, di ba? So, it should be logical na SSS yan. Nagbigay din twice from limited portability law. Okay. Tapos, paminsan-minsan, GSIS yan. The basis of labor law is police power. Its purpose is social justice. So what is police power? You know what it is from your political law. What is social justice? Go back to Kalalan versus Williams. Okay. I believe that you have memorized the definition. It is the humanization of laws and the equalization of socio-economic forces so that justice in its secular, rational, and objectively secular sense may at least be approximated. Okay. From this definition, there are twin functions, or social justice has twin functions, namely humanizing function and equalizing function. So what laws discharge the humanizing function of social justice? One of them is RA 7877, the Anti-Sexual Harassment Act, which is also a bar area. But the last time it was asked was in 2006. After that, wala nang gusto magbigay. Especially in 2008 when the bar examiner was Dean Pokis. Ayaw niyang magbigay ng sexual harassment. Siguro to avoid inviting attention to himself. Pokis is of course singular. This is a very important area actually. Maraming decided cases that later on I will explain to you that the tendency of our examiners, at least until 2006, was to give hypothetical questions. Ayaw nila sa decided cases, except in one bar here where the problem was based on Domingo versus Rayala, a decided case. Otherwise, hypothetical yan. I will teach you later on how to tackle hypothetical questions, and you will not go wrong. You will not go wrong. Okay. What about the equalizing function of social justice? You have your anti-discrimination laws, like the Anti-Age Discrimination in Employment Act, Solo Parents Welfare Act, okay, 9231, and similar anti-discrimination statutes. So they are there to discharge the equalizing function of social justice. Now, in regard SSS 8282, take note of the two characteristics of social legislation, in particular 8282. Namely, number one, it is morality free. And number two, it is non-discriminatory. Twice or thrice in the bar, the unmarried woman was given, the single mom, claiming maternity benefits. Okay, will you give her or withhold? Okay, the answer is give. No? Why? Because the law is morality free. It does not require marriage. Okay? Nakipag-affair kay Dean Pokis, nabuntis, nag-apply, as long as she has complied with reportorial requirements. That she has reported the fact of her pregnancy to her employer and the expected date of her delivery. Okay? That she has paid at least 3 monthly contributions during the 12-month period immediately preceding the semester of the contingencies of wedding, natural delivery, miscarriage, or cesarean section. Right? So, ganun. You will always give that single mom maternity benefits provided she has complied with the requisites of the claim. You tell the examiner, the reason is the law is morality free. What about the second characteristic? It is non-discriminatory. Do not make a distinction between legitimate children and illegitimate children. They are all primary beneficiaries of an SSS member. Do not make a distinction between natural parents and adoptive parents. The law is non-discriminatory. In the case decided in 2015, I'm referring to the case of Bartolome versus SSS not yet given in the bar, not in 2016, not last year. The SSS denied the death